This segment is brought to you by Asian Cultural Alliance.
In post-authoritarian Taiwan, the judicial system has never earned a trust rating over 50%. Dissatisfaction with the courts have reached over 70%. These indicators have spiked in recent years. The president of Taiwan's Judicial Yuan, Xu Zhongli, said during an academic law conference in January 2019 that political interference threatens the justice system, and the media's exaggeration of issues is to blame. Xu puts the public's distrust of the courts on the media, but more importantly, he acknowledges that the law has been tainted by politics. Things certainly aren't as bad as when Taiwan was a dictatorship freely doling out death sentences. However, judges who do not fall in line with the government's expectations can still be removed through administrative means. Presiding judge at Taipei District Criminal Court Hong Yinghua refused to switch out a judge handling former President Chen Shui-bian's case. She said she wanted continuity of justice. In 2013, Hong was accused of being unfit for the role of presiding judge, and an appraisal was carried out. Out of 104 high court judges, only 30 participated in an evaluation vote. 19 of those judges voted to remove Hong as presiding judge. She was ousted by a vocal minority. Judicial reform advocate Judge Ling Menghuang often writes opinion pieces criticizing those in charge of Taiwan's judicial system. The public has voted him an outstanding judge. However, in 2018, he was the only appellate court judge whose term was not renewed. He was removed in a 12-1 vote by a committee composed of government officials and public representatives. Under current circumstances, judges must obey and comply with the government if they want to get far in their career. Every judge must be politically sensitive. If this is the case for judges, then what is there to say about prosecutors who are direct envoys of the Ministry of Justice? Tsai's case against the three scholars have made her the first president ever to pursue legal action against civilians. Tsai's side uses its influence to insist that her education credentials exist. This case is proof that Taiwan is, once again, a party state. It's also a look at Tsai's place in judicial reform history. Prosecutor Huang Wei is the presidential office's preferred prosecutor. In July 2019, a cigarette smuggling scandal rocked Taiwan. National security personnel were caught smuggling thousands of cartons of duty-free cigarettes into Taiwan using diplomatic customs privileges. This incident revealed national security loopholes and implicated people at the Presidential Office, National Security Bureau, and the Investigation Bureau. People were outraged. How many people were involved in such unlawful behavior? How far up does this matter go? Was anything else smuggled? Does this case point to money laundering? These are all questions that developed in the wake of this egregious act. However, who could have guessed that the prosecutor assigned to the cigarette smuggling scandal was none other than Huang Wei? He was given the case by then Taipei District Chief Prosecutor Xing Taizao. Coincidentally, Xing was promoted in March 2020. Huang did not disappoint in his mission.
这个案子33天火速侦结起
Huang brought
诉
up 2 lowly majors on embezzlement charges. The other 27 individuals involved in this case were given deferred prosecution under tax evasion charges. All they had to do was undergo 6 hours of ethics training. Afterwards, Chen Minhua, a colonel assigned to the presidential office, was promoted to major general in November. The media poked fun at this event, saying that Taiwan owes the existence of this general to the ethics training he underwent. The Taoyuan District Prosecutor's Office should have had jurisdiction over the cigarette smuggling case. However, Taipei District Chief Prosecutor Xing Taizao took it over. The case reeked of diplomatic privilege abuse, but was handled as a tax evasion case by Huang Wei. It's clear that he was trying to downplay the scandal. Things don't end with cigarette smuggling. In September 2020, a bribery scandal hit Taiwan's legislature. Investigators supposedly explored 65 different avenues of bribery before finally searching the legislature. Several people, including legislative chiefs of staff, were detained. Prosecutors' investigation into the bribery scandal was not open to the public. However, they published press releases saying they discovered cash deposits as large as 9.2 million new Taiwan dollars and named the lawmakers involved. Text messages by former chairman of the New Power Party Xu Yongling were made public, showing his willingness to take bribes. However, evidence shows that Xu was the only legislator involved that didn't actually receive cash bribes. However, prosecutors went ahead with his indictment. He may not be charged with any crimes, however, his political career has been torpedoed by the prosecutor's office's press releases.
把脸蒙得紧紧的无党籍桃园立委赵振宇家中的保险箱被搜出920万元现钞，而负责行贿的白手套与搜狗案竟是同一。
This politically sensitive case is said to be the first shot fired along the 2022 election campaign trail. The prosecutor in charge, Huang Wei. Huang Wei is also the prosecutor in charge of the ThesisGate court battle. He has consolidated 15 cases related to Tsai's defamation lawsuit against the 3 scholars into one. Cases that were merged include Dr. Dennis Peng's countersuit against Tsai and cases from both Tsai's supporters and detractors. However, all 15 of these cases are different in nature. In some of the cases, no complaint has been filed, which is a basic component of any lawsuit in Taiwan. How can these intricate cases be bundled together? Furthermore, defamation and false accusation should not exist in the same case. This is how Huang Wei kills the ThesisGate court case. Political interference has permeated all levels of the justice system. Not only are prosecutors playing ball with the presidential office, but district courts, an entity that must remain fair and impartial, are subject to political influence as well. Tsai Ing-wen's case against the 3 scholars is a public prosecution. It wasn't until October 14, 2020, 406 days after the case was first filed, that it had its first hearing. Dr. Dennis Peng's civil suit against Tsai Ing-wen alleging that her thesis does not exist also did not have its first hearing until October 27, 2020, 323 days after the suit was first filed. Peng's case against Tsai was first filed on December 9, 2019. On January 15, 2020, Judge Zhang Yonghui dismissed the case 4 days after Taiwan's presidential election. Between its first filing and its dismissal, the case never had so much as a single trial. In order to downplay the fact that Peng's case had been dismissed without a trial, the Liberty Times, a newspaper loyal to the Tsai administration, published an article on December 13, 2019. In it, a lawyer said that there is no legal interest in proving the existence of a thesis and therefore does not merit a case. He likened Peng's questioning of the thesis's existence to questioning whether there were ghosts or aliens. It would have done nothing for the courts or the legal system. At first glance, this argument might seem reasonable on some level. However, there are still underlying implications that betray political bias. The thesis's existence is the core subject of several outstanding cases. It's not just an issue of contention between the 3 to 5 cases involving Peng and Tsai. Tsai's case against the 3 scholars is a matter of the thesis's existence as well. Furthermore, potential damages that might be requested in future civil suits resulting from the criminal case proceedings outcome is certainly a matter of legal interest. Say there are 2 people who claim to be father and son. Their relationship shouldn't be the matter of a third party. Now let's say a third party claims that the actual father of the son is someone else and that the first 2 have no blood relation. The father then files a suit against the third party for defamation. At that point, the case filed will be centered around whether or not the father and son pairing are related. The ultimate relationship between this father and son constitutes legal interest. The lawyer who wrote the Liberty Times article completely ignores the fact that Peng's case was dismissed before a hearing. However, such neglect reveals bias against ThesisGate. However, ultimately, the article proved to be a way out for Judge Zhang Yonghui. In order to prevent judges from using such an argument against ThesisGate cases, our lawyers on January 2nd, 2020 submitted justification for the case. They referred to articles within Taiwan's Code of Civil Procedure on legal interest to uphold the necessity of Dr. Peng's lawsuit. However, 2 weeks later, Judge Zhang went ahead with her dismissal of the case. Judge Zhang did not call Dr. Peng's case to court for one simple reason. The presidential office had already decided the outcome of the case for her. Zhang's reasoning for dismissing the case was exactly the same as the reasoning in the Liberty Times article. Furthermore, Zhang's reasoning seemed to work off of a pre-existing notion that Tsai indeed had a proper PhD. However, Peng's case wasn't asking about a PhD. It was asking about a thesis. Insistence that possession of a PhD is predicated on the existence of a thesis is the exact same reasoning used by the presidential office throughout this controversy.
也就是说，有拿到学位，就当然有缴交论文。
有学位就是一定有论文，有学位就是一定有论文。
To include a defendant's claim that their degree exists in a legal opinion is unusual to say the least. The published reason for dismissal was not written with the plaintiff and defendant in mind. Instead, it was written with the express purpose of manipulating public opinion. When ThesisGate first exploded in June 2019, North America Taiwanese Professors Association head Li Zongzi and DPP legislator Wang Dingyu took to Facebook to vouch for Tsai's PhD. At a time when people were wondering why they couldn't find Tsai's thesis in any academic institution, those 2 changed the narrative from "there's no thesis" to "Tsai has a degree." The same thing is happening here in the courts. ThesisGate lawyers honed in on this possibility long before it happened. On January 2nd, 2020, they sent in their justification for why their case should be heard. However, Judge Zhang ignored their reasoning. On January 15th, when the case was dismissed, media outlets announced that Peng lost his case. Again, this was changing the narrative and altering public opinion. This outcome was determined a long time ago. Let's go back to January 15th, 2020. That's the date Judge Tsai Ing-wen announced her dismissal of Peng's case. On 3:28 p.m. and 3:29 p.m. of that day, both the China Times and the Liberty Times published articles saying that Peng lost his case. Afterwards, other digital media outlets published their own versions of the story at around 5 to 6 p.m. that day. The headlines in those articles emphasized that Peng lost a case in which he accused Tsai's thesis of not existing. In reality, Peng's case was dismissed. He didn't lose. Those headlines may lead people to believe that the courts have solidly confirmed that Tsai's thesis exists. However, the interesting thing is both the Liberty Times and the China Times published their stories 2 hours earlier than any other media outlet. Their articles even beat the press release announcing Judge Tsai's dismissal by over 10 minutes. Could you believe it? Reporters from those 2 newspapers are prophets. Either that or they lucked out on blind hunches. Anyone with a computer knows that files contain detailed information about changes made to them. If we examine the press release Word file the Judicial Yuan sent out regarding Zhang's decision, we find something very interesting. Information on the file's source shows that the document was created on January 15, 2020, 3:24 p.m. The document was last saved on January 15, 3:47 p.m., meaning the press release wasn't finalized until that time. The news articles published by the Liberty Times and the China Times beat the final press release by a full 18 minutes, 19 if you want to get technical. The media began reporting on Zhang's decision at a time when Tsai herself didn't finalize her decision. Furthermore, ThesisGate lawyers found out about the dismissal through those 2 newspapers. Who is the true puppet master here? Was Tsai's decision really written by her own hand, or is something more sinister at play? After the courts of first instance issued their decision, ThesisGate lawyers immediately appealed that decision. There's no way Peng could lose in a case where the thesis's existence comes into question. That's because even the presidential office admitted that Tsai's thesis was lost.
为什么之前 LSE 的图书馆里面没有蔡总统的博士论文？我想刚刚从业的说明已经非常清楚。蔡总统经过 LSE 所有的程序，包括提交论文口试的题目，包括通过完成论文口试，到完成 LSE 相关的行政程序之后，这个获得 LSE 颁发的博士学位证书。那么35、6年前的论文既然已经提交，但纸本遗失，我想这应该不会是35、6年前提交论文的学生的责任。
However, the presidential office can't provide any evidence that proves Tsai abided by the so-called protocols at LSE. All they can produce is a replacement diploma from 2015. Furthermore, they refuse to send that diploma for appraisal. Isn't that suspicious? Dr. Peng visited the school libraries in London last year. The University of London's Institute of Advanced Legal Studies clearly said that they couldn't have lost Tsai's thesis. The ThesisGate camp has every reason to suspect Tsai's thesis doesn't exist. It has done its due diligence and has come up with nothing. It is now up to Tsai to present evidence proving her thesis exists and that it was placed properly in academic institutions. Furthermore, she must provide a proof that her viva was administered and who her external examiners were. That's the only way she can maintain that she had a thesis back in 1984. In the same way that Huang Wei is unwilling to carry out a search at Tsai's presidential residence, Judge Zhang doesn't dare hold a hearing over whether Tsai's thesis exists. At 11 a.m. on October 27, 2020, the Taiwan High Courts held appeal hearings for Dr. Peng's case against Tsai. Chief Judge Huang Mingfa presided over the case. This instance also marked the first time Peng's case was heard in any court 323 days after it was first filed. Representing Tsai was Lexel Partners' Lian Yuanlong, a lawyer with 30 years of experience under his belt. Lian has developed a close relationship with Tsai Ing-wen over the past few decades. He worked on a high-profile case for the DPP in 2012. In 2015, he represented Tsai in a real estate speculation case. In 2016, he represented Tsai Ing-wen's brother in a tax evasion case unveiled by the Panama Papers scandal. It's not an exaggeration to say that Lian is one of Tsai's most trusted lawyers. The High Court's hearing lasted for about 2 hours. The courtroom was packed to the brim with spectators. Presiding Judge Huang Mingfa began proceedings by defining what would constitute a thesis. He recited Judge Zhang's initial decision and then allowed both sides to give their opening statements. During the 2-hour hearing, Lian continuously relied on the argument that facets of the case were legally irrelevant. He claimed that there was no reason to hold a hearing over whether Tsai's thesis exists. Lian constantly said he didn't understand the plaintiff's argument. Peng's lawyers shot back, saying that they had filed justification for their case long ago. He said that if Lian didn't understand, then he could have deferred to that document. Judge Huang Mingfa eventually had to chime in and explain the legal perspective for the case. Lian couldn't accept Huang's terms, insisting that Peng's issue with Tsai still didn't have any legal interest. He said there was no way to know whether Tsai will seek civil damages over the case Peng has brought forth. Therefore, there is no legal interest between the two parties. But the fact that Lian mentioned that there's no way to confirm whether Tsai would seek civil damages is of utmost importance. Him suggesting that Tsai could potentially seek damages meant that it was possible she'd seek compensatory legal action. Not only did he admit that this case is a matter of the law, he also revealed that his side is not secure in its legal standing. Peng's lawyers asked the court to include Lian's statement in the record, which established that there was an ambiguity to the basic truths that had yet to be established. Because the truth sought lacked substance, then there was a basis for the case under the Code for Civil Procedure. Lian was left speechless. He had no choice but to turn around and refer to precedents to make his case. Peng's lawyer pointed out that for precedents to have legal basis, it had to be amended into law. Peng's case against Tsai is good for both the plaintiff and the defense. No matter what the outcome is, this will be an opportunity for the justice system to review information relevant to many other cases. However, out of fear that a thorough investigation and trial will take place, Tsai's entourage continues to withhold evidence. They constantly interfere with procedures, stalling court proceedings for 300 to 400 days. They are the ones that truly fear ThesisGate. The Tsai entourage's operation is quite simple. First, they interfere in as many things as they can, stalling whatever mechanisms necessary to delay results. Second, should actual investigations take place, they submit forged documents in an effort to back their false claims. Third, if inquiries are made abroad, then the entourage will use whatever diplomatic means necessary to cover its tracks. We have no reason to be optimistic when it comes to evaluating Taiwan's justice system. Judge Huang Mingfa took a different approach to Peng's case when compared to Judge Zhang Yonghui. By virtue of holding a hearing, Huang has done more than Judge Zhang. But what administrative obstacles await in the shadows ahead? Can Judge Huang remain just and impartial? Taiwan's judicial fate is now at a crossroad. We see that there are judges who are colluding with the president, bringing the justice system down a dark road. However, there are also judges who will go so far as to request evidence from faraway London. The thing is, justice shouldn't be served depending on which judge is overseeing a case. Even while the shadow of corruption threatens to overtake our country, we can still see vestiges of justice standing up to oppression. ThesisGate ultimately will give Taiwan's justice system a chance to become fully independent and impartial. This will be Tsai's biggest and final contribution to Taiwan's judicial reform.